Well, welcome everyone, and thank you for joining me today on the 14 ways to protect the ones you love. Hi, my name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. We serve clients in the state of Washington and in North Idaho. What we're going to be talking about today is estate planning and estate planning from an elder law attorney's perspective. If you have any questions, feel free to post them in the chat, or if you're on Facebook, post them there, and I will try to answer those questions as we progress throughout the discussion today. For those of you also who have joined us, we will be sending you an ebook that contains a lot of the information that I'm talking about. Feel free to take notes, but also know that I will be sending you some information. So, all right, well, why don't we go ahead and get started? Most people think that estate planning is about what happens when you die. And it's true, estate planning does focus on what happens when you die, what happens to your estate, where do your assets go, and who receives them. What I think is really important, though, for everyone to understand is that's not all there is to estate planning. In fact, I think more importantly, estate planning is about planning for the what ifs in life, planning for what happens should something happen to you, if you become disabled or incapacitated, or somebody in your life is disabled or incapacitated. That's planning for the what ifs. So estate planning isn't just about end of life. Estate planning is about what happens during your lifetime. Interestingly, or maybe not so surprisingly, the majority of Americans have no estate plan. According to a January 2023 survey by caring.com, as reported by AARP, only 4 in 10 Americans have an estate plan. And not surprisingly, the people who are older are more likely to have an estate plan. So I wanted to share with you a little bit about that survey. 81% of people who are 72 or older have an estate plan. 58% of who are called boomers, ages 53 through 71, have an estate plan. Not surprisingly, as we get younger, the Gen Xers, their ages 37 through 52, only 36% of them have an estate plan, and only 22% of millennials, who are ages 18 through 36, have an estate plan. And you will not be tested on the definition of who's a millennial, who's a Gen Xer, et cetera. I am just going by the survey so that I know, who is considered what, because I always find that really confusing. I'm a boomer. That makes it easy for me. But everything else, Gen Xers, millennials, not surprisingly, they are less likely to have estate plans because they're not thinking about what happens upon death. But they're also not thinking about what happens should they become disabled or should they lose capacity. Again, not surprising. Yes, of course, disability, incapacity, inability to manage your own affairs is far more likely to happen as you get older, but it also happens to younger folks. So as an elder law attorney, and what I mean by that is somebody who is knowledgeable about government benefit programs and conservator and guardianship programs, I think it's really important that I help educate people to understand about the importance of planning, not just for death, but for disability and incapacity. When I say disability, what I'm talking about, and what generally is understood by disability, is that you can't support yourself. You can't, make a living such that you earn a living. So you're going to be relying upon government benefit programs to support yourself. Now, somebody who is disabled, that does not mean that they lack capacity. Capacity is a little bit different. Lack of capacity or incapacity means you can't manage your own affairs. Typically, that would be a cognitive issue, that you can't, manage your financial affairs, your personal affairs, your medical affairs. But disability and incapacity sometimes do go together, but they don't have to. What's important to understand, whether it be for you or somebody in your life, a family member, is that you can put legal documents in place, estate planning documents in place that will make it easier to qualify for government benefit programs that help support somebody who is disabled or incapacitated. We'll talk about that. All right, let's move forward with the 14 ways to protect the ones you love. Obviously, have an estate plan and have, as a part of an estate plan, your living documents in place. The living documents are what protect you during your lifetime. Now, protecting you during your lifetime also has the effect of protecting the ones you love and your money during your lifetime. One of the biggest risks is having the state involved with your business. So number one on the list of 14 ways to protect your loved ones is to avoid a court-ordered guardianship or conservatorship. Keep the court, keep the state out of your business. If something happens to you, such that you become incapacitated, and there's no one who's legally empowered to act on your behalf, the state has no choice but to step in and order a guardianship or conservatorship over yourself and over your finances. There has to be somebody who can make decisions for you. And if you can't make them yourself, and if you haven't put into place your living documents, there's no choice. It's required, it's necessary. The state then is basically in charge of your life. And that is much more likely to happen for people who are younger. Why is that? Because they are less likely to have an estate plan. So let's say you are a boomer or you are older and you've gone to a lawyer. They will have prepared for you not just a will, but they will have prepared for you durable powers of attorney. And if your attorney that you met with didn't say, hey, you need not just a will or, what happens at end of life, but you need your durable powers of attorney. If they didn't say that, that's a real red flag to me. Because as an elder law attorney, somebody who helps clients who have disability, families with incapacity, I think the most important document you can have are those documents that keep the court and the state out of your business. Should there be, something that happens so you lose capacity, and those are going to be your durable powers of attorney. So having the durable powers of attorney in place will then make sure, if they're done correctly, that the court will not have jurisdiction over your affairs. You won't be in a guardianship or in a conservatorship. Durable powers of attorney, the best way to protect the ones you love. When I say durable powers of attorney, I am talking about the legal document that you, as the principal, sign while you have the ability to do so, while you have capacity. And what you do is you designate somebody to act on your behalf in case you can't do so. Financial durable powers of attorney and medical and healthcare powers of attorney. Now, it's okay to combine all of that decision-making authority into one document. It can be a combined durable power of attorney that says, I grant authority to my spouse to make financial decisions and medical decisions. That's perfectly fine. As an elder law attorney, I like to see them broken up so that there's a separate financial power of attorney and a separate healthcare power of attorney. The reason for that is, as an elder law attorney, we include our durable powers of attorney are quite robust, quite strong, have a lot of authority, a lot of provisions in them. And to combine them into one document is going to make a very, very long document. So that's one of the reasons I like to have them separate. Another reason is that you might want to designate somebody to be your healthcare decision maker, maybe your son or daughter, and then you want your financial power of attorney to be somebody else. And if you have the same document, it's too awkward. You can't designate separate people. So having the durable powers of attorney in place is the number one thing you can do to protect your loved ones. Because if you don't have that, then the state will become involved in your business. And that's very intrusive, very expensive, and very, very frustrating. Make sure you get good legal advice. Do not use a form. If you're going to use a form document, you're just guessing as to whether or not that is going to be an effective document. And guess what? The document isn't tested until something bad happens, until you do lose capacity. And if that has happened, there's no opportunity to fix it. So I think what I really want to bring home is the point that protecting yourself during your lifetime through really good durable powers of attorney, in case anything happens to you, such that you lose the ability to make your own decisions, is probably the greatest gift you can give to your family members, those who are going to be helping you if you do lose capacity. Just like I said, don't use a form. I also don't recommend that you have a power of attorney drafted up by somebody who is not an elder law attorney. And, any estate planning lawyer might disagree with me. They might say, well, these are just forms and documents, and I can prepare an effective, durable power of attorney. I understand what the statute says, in Washington, what needs to be put in the durable power of attorney. But my response to that would be have you ever applied for a government benefit program? Do you know what is required if there needs to be a Medicaid application for long-term care benefits? Do you know the steps that need to be taken to protect assets from state recovery? And if the estate planning lawyer responds, no, of course, I don't do Medicaid, I'm not an elder law attorney, then I would say then you really might not understand what an elder law attorney would include in a general durable power of attorney for finances that you would be unaware of because you don't know the importance of having that authority in those documents. I do recommend in estate planning an elder law attorney and someone who does Medicaid applications. I want to share with you a story about an attorney who had prepared for the husband and the wife what appeared to be, at least to the attorney and to the husband and wife, perfectly fine estate planning documents, perfectly fine durable powers of attorney. And it came to me because there was going to be a guardianship. So what the attorney had done is they had prepared the durable power of attorney naming the wife, who happened to be a new wife, and naming the son from a prior marriage, as joint decision makers for the husband's durable power of attorney. Husband lost capacity. Now, in order to manage husband's affairs, the new wife and what would be the stepson to her had to agree on everything because they were attorneys. In fact, they had to agree. They weren't independently empowered. They had to agree jointly on all decisions, and they couldn't agree on anything. What appeared to be an okay power of attorney based on the actual document failed completely because the wrong decision makers were named. I do not recommend that you ever name two people who will never get along. In fact, I never recommend that you name two people jointly anyway. Sometimes there's an exception where it makes sense, but as a general rule, name one person you trust. Name a successor to that person after that, and name a next successor person. And don't require any of the people that you've named to act jointly. As a result of the power of attorney that I just mentioned to you, where they didn't name people in a successor level, they named them jointly, they had to make joint decisions. The case ended up in court in a court-ordered guardianship with this gentleman's affairs completely managed. And because neither one of the wife or the son could get along, it ended up being what's called a certified professional guardian. Some outside third person had to take over and manage the husband's affair. So there's a complete failure of the durable power of attorney, all due to the attorney who drafted it not understanding the practical aspects of what does it mean. And it seems common sense, I think most of you would agree, that you would not put the new wife and the son from the prior marriage together and force them to work together, because they didn't. And it was a complete failure. Kind of along those lines, one of the things that people often misunderstand, if you want to protect your spouse, have a good durable power of attorney in place. And you might say, well, we're in Washington. This is a community property state. I don't need a durable power of attorney. I mean, my husband and I are on the same bank account. We both can write checks. True, because you're joint owners of that asset. And it's a bank account. But that doesn't mean that you have legal authority to act on behalf of your spouse. In fact, you do not. Think about your house. You're both on title to your house, right? And let's say you need to sell your house. Well, you both need to sign on that sale. What if your husband loses capacity and there's no durable power of attorney? Who's going to sign on the sale of that house? You might think, well, I can because I'm the joint owner, right? No, you can't. If you don't have a durable power of attorney over your spouse and you need to sell that house, that joint asset, and your spouse is incapacitated, there will be a court-ordered guardianship with multiple steps required as to how you actually have to sell the house. So you, as the owner of that house, are completely frustrated. You cannot sell your house. I have seen that. It's a terrible situation for the spouse to be in. They feel like they're completely out of control, because they are. They're not in control of basically their assets. It feels like they're not in control of their life because the court is involved with it now and they can't even sell their own home. It's a really sad situation. All can be avoided by having a good, effective power of attorney. So number one is, avoiding a guardianship, have a power of attorney. I'd say number two is have a really effective general durable power of attorney for finances, not just to avoid all the situations I've just described, but to even go beyond that. So this is where the elder law attorney in me comes out. What I want to talk about is about having effective durable power of attorney. That's a kind of document that prepares for the what ifs, not just the what if somebody loses capacity. Let's say you're married and your spouse loses capacity. You've got a durable power of attorney. The court's not going to be in your business. That's great. But let's go a step further. Your spouse needs long-term care, and you don't want to spend all of your assets paying for their care, because you go to an elder law attorney and say, oh, we can qualify your spouse for Medicaid benefits. You don't have to spend down all your money. There's lots of strategies so that the state will pay for your care. The elder law attorney is going to be looking for provisions or authority in the durable power of attorney that allow not just qualifying for Medicaid, but protecting the assets of the couple when the ill spouse is on Medicaid. Let me give you an example of a durable power of attorney that was, again, prepared by a non-elder law attorney. So let's call them Frank and Ellen. Ellen has advanced dementia, and it's too late for her to prepare new estate planning documents. She does not have the legal capacity that allows her to now sign new documents. So even though they're in front of a Medicaid elder law attorney now, they're coming with old documents that weren't prepared by an elder law attorney. And so we're stuck with what Ellen's documents are. We can't fix them. Let's say, and this is very common for a couple, one of them has dementia, the other is more physically frail. The physically frail person, though, does help help the spouse with dementia. It works. It works as long as there's not a big crisis. It might be hard, but it works. So Frank is caring for Ellen at their home. And let's say her care needs increase because Frank has a health decline or something else occurs that, it's no longer working. Let's say that the couple is financially eligible at this point for Medicaid benefits. And so that we can then, apply for Medicaid. Medicaid pays for Ellen's care at the care home. Frank visits her every day. Things are going okay. But remember I said that Ellen had not the greatest documents. Because of how Ellen's documents read, we were precluded from doing things that we would want to do. Here, let me give you an example. Maybe you've heard of a community property agreement. That's and there's different kinds, but some community property agreements say, hey, when I die, everything becomes my spouse's automatically. And the community property agreement typically may not be revoked unless both of the spouses want to revoke it. But we don't have the authority in a durable power of attorney to revoke that document. Similarly, general durable powers of attorney drafted by non-elder law attorneys might not grant the authority not just to revoke such a document, but to enter into what's called a separate property agreement. You see, if we have Ellen on Medicaid, we want her to own no assets. We want the house, any bank accounts, anything else to be in Frank's name only for a number of reasons. In particular, we want everything in the well spouse's name so that when Ellen dies, the state does not have any right to collect a lien upon the assets that the couple has for all the benefits they've paid to Ellen. So it's standard practice for an elder law attorney when one of the couple is on Medicaid to put all the assets into the well spouse's name. Sometimes we can't do that. Sometimes, since we can't do that, that means that the state is going to end up with all of the couple's money. Now, the state will not collect on the lien while the well spouse is still alive, which is good, but they will collect upon the assets when the well spouse dies. So rather than the kids getting the assets that they could have gotten, because we could have completely avoided the state's lien in Washington had we put all the assets in the well spouse's name, instead of that, the state ends up getting everything and the kids get nothing. So sometimes I think, of course, estate planning documents, particularly if you go to someone with expertise on Medicaid or elder law, they are going to cost money. And a lot of times people don't want to pay for professional services or for legal services. So they do it themselves, or they do it on the cheap, or they do whatever they can. Keep in mind, especially when it comes to long-term care, that by doing so, that might end up costing them the entirety of their estate, all because we lacked the provisions that we needed to protect assets for the couple. So when you're thinking about durable powers of attorney, I want you to keep in mind that it's, in my opinion, that they are the most important documents you can have, is that they allow us to protect assets for the couple and then ultimately for their beneficiaries, for their children or whomever. All right, number 3, have a living will. That protects your loved ones. Actually, I have to admit something. I hate the term living will because it's a misnomer. It's not a will, but it's commonly called that, so that's why I'm using it. A living will is actually properly known in Washington as an advance directive or a healthcare directive. What it is, it's that document where you put in writing what your wishes would be should you be at end of life. So it's called a living will, it's called an advance directive, it's called a healthcare directive. The reason that you want to have this to protect your family is that you are putting in writing what you want. If the doctors say to you that, well, if you're able to process it, but if not, to the healthcare agent, the person you've appointed under your power of attorney, they say to you, this is end of life. And what that means is permanent vegetative condition, terminal condition. The doctors put it in your chart that no matter what they do for treatment, you're not going to get better. It's simply prolonging a dying process. If any of you have been in that place, you've had to make decisions for family members, it's a really tough place to be in. And especially if you're just trying to do your best and you don't have anything in writing to guide you, There's sometimes some guilt involved with saying to the doctor, please withdraw that feeding tube, that breathing apparatus. Please stop the treatment. This isn't what mom would have wanted. It's the right decision, but there's no getting around it. It's a tough place to be. How you make it easier for your loved ones is you put it in writing, that you say, in the event that I'm at end of life, I do not want artificial hydration, nutrition, or any of these other what are called heroic measures to prolong the process of my dying. Instead, please give me comfort, give me medications, even if it actually hastens my death because the morphine slows my respiration. I would prefer that to die peacefully than to linger, a death that no one wants. So put it in writing. Why? It gives more guidance to your decision maker, and it helps alleviate guilt. And that's a really important thing to make things easier on your loved ones at the time of your passing. I want to kind of step back for a moment because this is something that just came up this morning. I want to share it with you. Sometimes clients think that if they put in their healthcare directive, no heroic measures, that direction will apply to acute health treatment. And so I want to make sure that I want to share this with you, that when you say you don't want heroic measures, that only applies when you are at end of life. The doctors have put in your chart that they've done everything for you. They've done all the emergency, everything they can do, surgery, stents. They've done everything. Doctors don't give up easily on you. They've done everything. So clients say, well, what if I have a heart attack? Does that mean everybody's going to be hands off? No. You're going to get emergency medical treatment and treatment at the hospital. Healthcare directive doesn't mean you won't get that. What it means is when all of that has been tried and you are not going to get any better, you are dying, that's when the healthcare directive comes in place. So don't shy away from signing a healthcare directive thinking that means you've given up. Not at all. All it means is you're clearly stating your direction, what happens when you are truly at end of life. And I do encourage our clients to speak to their loved ones, not just their healthcare agent, the person they've designated under their power of attorney, but, around the family table at whatever, appropriate time. I think Thanksgiving's a good time, but that's me. To say, if I'm ever at end of life, please let me go. That's what my wishes are. I don't want to be a burden. I want to have a quality of life, etc. Actually having the discussion, I think, is really important. I think it's easier for people as they get older to have this discussion. But still, it's helpful for the people that you love to talk to them about it. And maybe not just for yourself, maybe you'll learn something about them. We're always thinking that it's the people who are older who are going to, die first or have health problems first, but that's not always the case. So sometimes it's good to have a discussion with all your family, including your younger family members, because, it's better to have information than not, in my opinion. Number 4, authorize your healthcare agent to obtain information from your medical providers. This seems like a no-brainer, right? Every time you go to the doctor, they usually present to you a new, what's called a HIPAA authorization. That's the medical privacy laws. Why they do that is that your medical chart, your medical information is private, and your healthcare providers can't share it with anybody unless you say that they can. Our healthcare powers of attorney have within that document HIPAA release authorization language. Not everybody's healthcare power of attorney or just combined power of attorney includes that important language. It seems like it's unnecessary, but it's really not. Your healthcare agent can't make decisions about you unless they can get information about you. So the HIPAA authorization allows your healthcare providers to give information to whomever's making decisions for you. Your HIPAA authorization, so it's different than the power of attorney for healthcare in that in the power of attorney for healthcare, you are granting authority to somebody else to give direction about your health decisions. They're directing your health decisions because you can't. The HIPAA authorization, on the other hand, is allowing your healthcare providers to give information to your loved ones. And that might obviously include your healthcare agent, but there might be other family members who aren't your healthcare agent that you want to make sure that they can get information about you. I do caution clients, though, when they're thinking about who to give authority for, family members to get information. You don't necessarily want to give access to your healthcare records to everybody. So, you have to think about, who do you really want to have access to get information about you should you be in the hospital or talk to the doctor. Sometimes where we really see people running into troubles with not having these legal documents is with unmarried persons. When I started this, discussion, we talked about 4 of 10 Americans don't have an estate plan, and a lot more than that go into the hospital. So the doctors need to have some kind of default backup system for all those people who don't have estate planning documents, powers of attorney that they need. So most states, Washington does as well, has a statutory authority that a healthcare provider can, if in the absence of a power of attorney document, that they can look to a family member to make decisions about the person who's incapacitated. So, the spouse, for example, can say, this is what I want you to do for my husband. If there's no spouse, that's an unmarried person, then they look at the children, and not just like the oldest and the next and the next, all of the children. So it's like a joint decision-making authority. So there is this backup plan when people don't have powers of attorney that allows the healthcare providers to speak to somebody to get direction about health treatment. Where this comes to be a problem is for unmarried persons. And that's not that uncommon. Younger generations are statistically less likely to get married than they used to for whatever reasons. Even older couples, they're not married, they're not registered domestic partner, but they live together, and for all intents and purposes they act like a married couple, but they're not married and they're not a registered domestic partnership. In that situation, if that one of the couple is in the hospital, the person who is their partner has no right to be at the hospital, to get information, to give direction. They are basically excluded from their loved one's health care. And this is something that people don't necessarily think about, is they need a legal document that grants them authority. And if they don't have that legal document, they are out. And let's say it's an older couple and unmarried, who's going to make decisions? Not the partner in the couple, but it would be the adult children who are making decisions. So not a great way you're already dealing with a terrible situation, your loved one's in the hospital, and you have no rights to even learn anything. You have to rely on other family members. So particularly for unmarried people, critically important that they have durable powers of attorney in place. I mentioned registered domestic partners. We know what married means. Registered domestic partners are for people who are above a certain age, and let's say they don't want to get married, because if they were to get married, they would lose, their late spouse's pension or Social Security or something like that. So in Washington State, we acknowledge that there are people who want to be together, they want to have marital rights, but they don't want to lose the benefits of being married to a prior spouse. So you can be a registered domestic partner in the state of Washington. All right, so let me move on. I've been talking about what I call living documents. I think they're the most important documents you can have to protect your loved ones. Let's talk about what most people think about now when they're talking about estate planning, which is what happens when you die. How do you protect your loved ones when you die? One of the ways you can do that is you can avoid Probate. Most people think that probate is to be avoided at all costs. We'll talk about that, but you can avoid probate. What is probate? Probate is the legal process to administer somebody's estate when they die. It is a court process. Either the will is filed with the court, or if there's no will, it still goes through the court under the laws of intestacy. Probate in the state of Washington is a very straightforward process, but of course, if it's going to be easy or if it's going to be difficult depends on a lot of things, including how good was the estate plan and what are the dynamics of the family members that are left behind. So that's probably one of the reasons that probate sometimes is looked at like, oh, you should avoid probate. You can avoid probate, and you should avoid probate if it makes sense. How are you going to know whether it makes sense? You need to talk to an estate planning or elder law attorney. Let me give you some guidance about whether it makes sense to avoid probate. You can avoid probate if your estate is pretty simple, and if there's no benefit. You can avoid probate. Most people think that the way to avoid probate is by having a revocable living trust. That's a trust that is created during your lifetime. You create it. You're the grantor, you're the trustee, you're the beneficiary, you're everything wrapped up into one. For you to avoid a probate, you put your house in the trust, your bank accounts in the trust, you do everything right. And the reason that you did that was so that on your passing, all the assets go according to the terms of the trust to wherever you want them to go, and you didn't need to file anything with the court. And it can be a really good estate plan to set up your estate plan to have a revocable living trust and avoid probate. In some states, it's critical that you do so. California, for example, where it's quite expensive. In Washington, whether or not most attorneys in Washington, at least based on my colleagues and what I understand, they will really go with whatever the client wants once the client understands the benefits of having a revocable living trust versus having a will. And we'll talk about that. But a revocable living trust can be a really good way to set up your estate plan to avoid probate. That is a very good option for many clients. If you have a revocable living trust, and if you have one, you know that you also have a will. Why is that? Because many, many times revocable living trusts aren't funded correctly, aren't understood well. And what happens is the person dies, and not only is there a revocable living trust administration, there's also a probate because some asset wasn't put into the trust that should have been put in the trust. So the will, it's called a pour over will, is to capture that asset, put it into the trust. So I've talked at other times about revocable living trust. I'm not going to get into a great depth or detail about it now, but it can be a good way to avoid a probate if it's done right. A revocable living trust isn't the only way to avoid a probate. You can do so very simply by, for example, you have a house and you want it to go to your child. Do a transfer on death deed. You have a bank account and you want it to go to your child. Do a pay on death provision. You have life insurance or IRAs or 401ks. You do beneficiary designations that says where it goes. If you properly set up all your assets, you avoid a probate. You didn't need a trust. You just avoided a probate because everything passes virtually automatically on your death. In order to do that correctly, though, you likely are going to need the guidance of an estate planning or elder law attorney to do that. Oh, and by the way, when we set up estates to avoid probate, we will always have a will as a backup because just like with a revocable living trust, it's not that uncommon for people to forget about an asset and they don't set it up as they were instructed. So there needs to be a probate or a small estate affidavit. But you can avoid probate in the right situation. That is something that you can do to protect your family against having to go through an otherwise unnecessary probate. Another way to protect your family is actually to have a probate on your death. And this is really misunderstood. And the reason for that is that people think, why would I want my family to have to go through a probate on my death? That's a lot of work. There's legal fees. That's a hassle. Right. Anytime that there needs to be an estate administration, a probate, it's going to involve work. It's going to involve fees. Hopefully it won't be a big hassle, but it is work. So why would anybody ever want to have a probate? The reason for that is it protects assets and it can protect family members. Let me give you the biggest reason we recommend probate. It has to do with when we have a married couple and one or both of that couple, let's say they're older, and you probably know statistically, the older you get, the more likely you are to need long-term care, but you want to protect assets for your spouse. So if you die first, then your spouse is not going to become impoverished through them having to spend all the money on long-term care costs. A last will is the way to protect your spouse against becoming impoverished from long-term care costs. And I'll explain how that works. In the state of Washington, it's the only way to protect your spouse from having to spend down all the money they inherit from you before they can qualify for Medicaid. It's not just about your spouse. So anybody who needs any kind of asset protection, special needs child, or any other person who might be on government benefits, having a will with the right kind of trust in it is going to protect your loved ones. So I talked about the couple. Let me give you more detailed information about how it would work. Let's say we have Joan and John, and they have $1 million estate. Joan has advanced dementia, but fortunately, she and her husband, John, got their estate plan prepared by an elder law attorney before Joan lost capacity, before she lost the ability to put a plan in place. And John cares for her in their home, and they're doing okay. But if he passes first, Joan is not going to be able to stay in the home. She needs 24/7 care. She's going to move into a care facility. John dies. Now, with standard estate planning, everything goes outright to Joan, no asset protection, no trust. If they have that 3-prong community property agreement, everything goes to her. She's going to need to spend down $1 million on her long-term care before the state will pay for her care, and then the kids will end up with nothing. That is a very common, unfortunate estate plan. Unfortunately, they went to an elder law attorney and they have the correct estate plan for them, which is when John dies, we know that at least 1/2 of the assets, at least $500,000, are going to go through probate. This is why probate's important, and fund this trust for Joan, the survivor. At least $500,000 will go into the trust. So worst case scenario is that she will need to spend half of the assets down on her care, but at least $500,000 will be in that trust. Medicaid doesn't count anything that's in that trust, anything. It's exempt. It's not countable. It's not lienable. It doesn't interfere with eligibility. The fact that Joan has $500,000 in a trust is not going to interfere with the state paying for her benefits. At some times, we can protect up to 100% of the couple's assets. Let's say we know John is going to be dying. Then they've done a separate property agreement where they put all the assets into the name of the dying spouse. Joan owns nothing. $1 million, the entirety of what was the couple's estate, can fund this trust for Joan. She's immediately medically eligible. She doesn't have to apply for Medicaid, or the trustee doesn't have to apply for Medicaid if it's not appropriate, but she's eligible. So the option is that she can go on Medicaid and the state can pay for her care, despite the fact she has $1 million in a trust. That money is there to ensure that she will never become impoverished. She will always have the best quality of care, the best quality of life that she can. And at the end of the day, when she dies, the state gets nothing. Everything goes wherever they wanted it to go, the couple, to their kids, or wherever it would go. The example I'm giving you is, why would you want probate? Because you want to make sure your spouse doesn't become impoverished. Yes, let's say you had to pay $5,000, $10,000 for the cost of a probate. You've protected $500,000, $1 million, or whatever the dollar amount may be, because you had a probate. That's a benefit. And that benefit that I just explained to you in Washington State can only be obtained by going through a probate process, because a will is the only way to establish this type of trust for the surviving spouse. That's one of the benefits of having a probate. And it's not just for your surviving spouse. We'll get to talking about other ways to protect your loved ones. This trust that I just explained to you would protect against any unnecessary estate taxes. In Washington, our estate tax level is $2.193 million. This trust that I just explained works as a tax protection trust as well. It protects not just your spouse, but anybody who might need asset protection. Maybe you have an adult child who has lifestyle issues, drug or alcohol. Gives creditor protection. Sometimes the probate is a really good idea so that we can get rid of any creditor's claims that aren't valid or shouldn't be paid or can be excluded. Having a probate can be a really important way to protect the ones you love. Number 7, how else can you protect the ones you love? Appoint the right executor or the right trustee, the right person. Sometimes people say, oh, I should just name my oldest child. Maybe, but are they the best person for the job? See, you get to choose who will be the executor. It's also called the personal representative. It's the person who is administering your estate. If you have a revocable living trust, they're called the successor trustee. Regardless of whether it's a will or a trust, you're naming the person who steps in after you to administer your assets and make sure everything is done correctly. You get to do that if you have created an estate plan, if you have created a revocable living trust, or if you've created a will. Without that, we'll say you don't have that. Let's say you don't have a will and you're thinking, well, I don't have an estate plan, I don't have a will. If you don't have a will or a trust, the state has a plan for you. The state says where your assets go, and the state will name who your executor is. I want to clear up a misconception. Sometimes people think if I don't have a will, the state gets all my money. No, that's not true. Generally speaking, if you don't have a will, your spouse gets your assets. If you don't have a spouse, your kids get your assets, or your grandkids, etc. But that doesn't mean that the right person is going to be administering your estate. Without a will, it becomes more complicated. The state will name the person. Give some thought to who is best suited for serving as the executor of your estate. Talk with them, make sure that they're okay with it, and then name somebody after them and name a successor as well. How you can make sure that your family deals the best with things after your death is that you've got a good plan and you put the right people in place. I know we're coming 10 minutes before the top of the hour, so I'm going to move a little bit more quickly. Number 8, avoid disputes. Kind of like what I was just talking about. Because of you having a good plan in place, you will avoid disputes in the settlement of your affairs. That is really one of the main reasons that you have an estate plan, is to make sure that you don't leave things unspoken, not in writing. It leaves it kind of messy and confusing. Protect the ones you love by having a good estate plan. It avoids disputes. Avoid unintentional disinheritance. Maybe you like your kids, but you've remarried later in life. If you have the typical, what I call an I love you will, everything goes to my spouse outright, and then you remarry later in life, and that's the kind of plan you have, how do you know your kids are going to inherit anything from you? And you probably have seen this. I know lots of our clients are familiar with the situation, is that late in life, people remarry and they die first. They've had kids from a prior marriage. All the assets go to the surviving spouse. Surviving spouse then has no obligation to provide for your kids. They inherited everything from you. Maybe their kids will get everything. Your kids will get nothing. You can make sure that your kids are not disinherited unintentionally by having a trust in your will. Again, that's one of the benefits of having a probate. Number 10, protect your kids against a divorcing spouse. You can do this through a will. You can do this through a trust. On your death, what you say is that the assets that go to my children are going to go to a trust for my children. They can even be their own trustee. You can even set it up so that it's not within their own estate for tax purposes. You can set up a lot of ways. But what it does is that if they inherit from you into a trust that you have set up for them, if they later are getting a divorce from somebody, the divorcing spouse can't grab those assets that they inherited from you because they're in a trust. So they are protected from divorcing spouses. Number 11. This is for people who are younger folks. Make sure you have a will that names a guardian for your minor children. So people who are younger are less likely to have an estate plan, and they're more likely to have minor children. Accidents happen at any time in life. And if that person dies, if the parent dies, and both parents are either deceased or there's nobody who is a parent who's able to care for the minor children, who is? Who's going to take care of your minor children? It's really important that you take the time to think through who would raise my kids if I'm not able to. And of course, we're talking about minor kids. And if you're a grandparent like me and you're thinking about that, you talk to your kids. If something were to happen to you and, your spouse, who will raise my grandkids? It's really important that they put it in writing so that there isn't any dispute. Without it in writing, the court is going to be listening to lots of arguments back and forth from family members that think that they should be the guardian. It's a terrible thing to do to minor children. Make sure you have a will. Put it in your will. Who's going to be the guardian of your minor children? Number 12, you can provide for your grandchildren. You might want to provide for them in a trust that you create through your will or through your revocable living trust. Set it up such that you might say, well, I just want everything to go to their parents. The parents will provide for the grandkids. That's fine. But you can, as a grandparent, set up a trust that your grandchildren will inherit from you, that they will have enough money that they can do whatever education, whatever travel. Providing for your grandchildren is really important, I find, with my clients that have grandchildren. That's something you can do to protect the ones you love. Number 13, do a personal property list to provide for special assets. You probably aren't surprised, but sometimes the thing that bogs down a family after somebody has died isn't like the money or the house, but it's the stuff in the house. It's the lamp, for example, or something that is, has sentimental value, and that bogs people down. As a preparing an estate plan, you can create what's called a personal property list, and you can give away, any kind of assets that are important to you that are not bank accounts, not property, like real property, but cars, jewelry, anything that somebody might really want, paintings, artwork. Do a list, say who gets it. And number 14, near and dear to all of our hearts, I'm sure, are pets. Provide for your pets. You can actually, in Washington State, do a pet trust. It's provided for by RCW 11.118. That's a real formal way. You can put it in your will that there's going to be a trust. Another way to do it, even though this might sound heartless and cruel, but your pets are considered personal property. So you can put it in your personal property list I just talked about to provide for your pets, that this person should get my pet. And then you'll want to set up some funds separate of that that you've named a guardian for your pet, so that you can ensure that the pet that you love so much is going to be taken care of when you're gone. So coming up on the top of the hour, those are the 14 ways to protect the ones you love. If you have any questions, we put it in the chat here. Reach out to us. We're ELG Estate Planning. Our website is elgwa.com. Our phone number is 509-468-0551. If you're watching this, not during the live broadcast, but later, And if you're seeing this on our YouTube channel later, please feel to subscribe. If it's content that you like, give us a thumbs up if you like it. Anything that we can do to answer some of the questions, if I've raised questions, reach out to us. We are happy to help you set up the plan that's going to protect the ones you love.